This. Yeah, sure. Thank you. Should I do a few tips and downs? Okay.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In Re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as a arraignment attorney on behalf of Beth Bridgman.
All right, good morning,
Although I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance.
Okay.
No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am
now's
waiving,
not the time.
I am not waiving any of my
Ma'am,
rights.
ma'am, okay, thank you.
And Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull the chair up, so thank you.
Well, then, if you want, I have no problem. All right.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know? Well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the. Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause. And she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the State Attorney General's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
You want to subpoena a witness. If you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
if you want to subpoena somebody, what you would do is you go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant, but everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to.
Ms. Richmond,
Okay, I get it, Judge Gothier. I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the codes and statutes.
Is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training in researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to. No,
I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yeah, Ms. Richmond, if you want to represent yourself, it's a little bit more work.
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with, or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll
all right.
Those
Thank you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf, submit a subpoena to the clerk's office that I would
Right.
review. It'd be the district court office
Okay.
that I would review, and I would issue the subpoena. If it's
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of other
get it,
charges to set
but
the-
I
Right.
appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate
And Mr.
any
Chairman,
clarification.
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
Oh, she's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. Of course.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right.
That's why it's called common.
You set the hearing date.
Okay.
We'll bring you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor,
that's
part
the
of the-
bond question. Any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf, would you like to-
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed. this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut off the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It wasn't
didn't,
an offer, it was an order
sorry,
to appear.
they didn't actually hand it to
People just
me.
refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety to the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to get one today, Ms. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's right. All right, we'll adjourn.
That's right.
I know. She's only up here from North Carolina. Work with all you guys.
Paste your courtroom transcript here. A courtroom transcript is missing the original proceedings because the uploaded text mixes the court hearing with a YouTuber's own commentary. Below is a clean, neutral narration based only on the courtroom events and not the creator's opinions. Beth Bridgman appeared before the court to answer 2 criminal contempt allegations arising from an earlier criminal case. According to the court, the first allegation involved the unauthorized practice of law and interfering with the defendant's opportunity to meet with appointed counsel before arraignment. The second allegation stemmed from her failure to appear at a previously scheduled show cause hearing after allegedly returning the court's notice cut into pieces with a written statement rejecting it. From the beginning of the hearing, the defendant challenged the court's authority, insisting she was appearing only by special appearance and arguing that she was a living soul, rather than the legal identity reflected in court documents. She repeatedly questioned the court's jurisdiction, claimed common law protected her position, and argued that she had relied on advice from an investigator who allegedly told her she was not required to appear. She also maintained that the charges had changed and demanded legal authority supporting the allegations. The prosecution's position, reflected through the court's explanation of the allegations, was straightforward. The issue was not merely the defendant's legal theories, but whether she had interfered with court proceedings and intentionally failed to obey a lawful court order. The judge repeatedly explained that those factual disputes would be decided at a later contempt hearing, where both sides would have the opportunity to present witnesses, cross-examine testimony, and introduce evidence. One of the most significant courtroom moments came when the defendant dismissed appointed counsel and insisted on representing herself. Before allowing that request, the judge carefully confirmed that she understood the possible penalties, up to 93 days in jail and a fine, and the risks of self-representation. Although she frequently interrupted the proceedings and disagreed with court procedures, the judge concluded that she understood her rights and was knowingly choosing to proceed without an attorney. The judge also addressed the defendant's repeated reliance on common law arguments, explaining that Michigan courts are bound by state statutes, constitutional provisions, and decisions of the Michigan Supreme Court. He emphasized that any constitutional or procedural challenges could be raised during the scheduled contempt hearing, but would not prevent the case from moving forward. At the conclusion of the hearing, the judge entered not guilty pleas on both contempt allegations, scheduled a future evidentiary hearing, granted the defendant's request to represent herself, denied her request for a jury trial because contempt proceedings do not provide that right, and set a $10,000 cash or surety bond after determining there was a significant risk she might refuse to appear again based on her previous conduct. If you found this courtroom analysis informative, be sure to like the video, subscribe to the channel for more in-depth courtroom breakdowns, and share your thoughts in the comments. Do you think the judge struck the right balance between protecting the defendant's rights and maintaining courtroom authority? Let us know your perspective below.